Hey, A-level law students, welcome to what I'd honestly call an absolutely essential explainer. Have you ever found yourself just staring at a past paper trying to guess the exact magic words the examiner is dying to read? Well, you are in exactly the right place. Today, we're taking the actual feedback, the most common pitfalls, and the grading secrets straight from the recent A-level law examiner's reports, and we're distilling the whole shebang just for you. This is literally your insider's playbook. Okay, let's dive into this. We are going to totally demystify the grading process for you. Because, look, when you sit down in that exam hall, you shouldn't be guessing. You need to be executing a really precise winning strategy. Think of me as your coach today. We are reviewing the game tape from last summer's exams to make absolutely sure you score the maximum points possible. So, here's the game plan for today. We'll look at the examiner's top secrets, cracking assessment objectives, English legal system pitfalls, nailing criminal law, contract law tactics, and finally, winning exam strategies. All right, let's kick things right off with Section 1, the examiner's top secrets. So the absolute biggest pitfall examiners saw across all papers, it's students just ignoring command verbs. For example, when a question asks you to identify, like identify two types of alternative dispute resolution, listen, the examiner literally just wants a list. Mediation, arbitration. Boom, you're done. Writing a massive paragraph defining them, it earns you 0 extra marks and just steals your precious time. Actually, the examiner's report explicitly calls this out. They wrote, valuable time is being spent on rewriting or paraphrasing the questions, which is not necessary. Guys, the examiner already knows the question. You get absolutely no credit for setting the scene. So scratch the intro and jump immediately into your legal analysis. Moving right along to Section 2, cracking assessment objectives. Now, this right here is the holy grail for high marks. You absolutely have to understand the difference between AO2 application and AO3 evaluation. Let's say a student writes a generic AO3 evaluation, something like, a disadvantage of juries is that the way the verdict is reached isn't known. I mean, that's okay, but to elevate that into the top mark bands, you've got to support it with AO2 application, meaning specific case law. So adding something like, as seen in R.V. Young, where the jury used a Ouija board. And this brilliantly illustrates exactly what examiners are hunting for. In fact, examiners recommend using this exact cheat code sentence starter, as seen in the case of blank, where blank. It is such a simple trick, but it seamlessly blends your AO2 application and your AO3 evaluation. A quick sentence or two following the where is usually all you need to beautifully illustrate your point and secure those top marks. Okay, let's shift over to Section 3, English legal system pitfalls. For this paper, precision with your terminology is totally non-negotiable. Like, if you use the word guilty in a civil law context, that instantly signals to the examiner that you're a bit confused. You really need to know your court hierarchy inside and out. For example, an appellate court is empowered to hear an appeal. But remember, the Supreme Court operates very distinctly from an intermediate appellate court. Don't mix those up. And definitely don't confuse the House of Lords or Commons when you're discussing divisions of the Court of Appeal. Now here is a massive tip straight from the report about civil case allocation. You've got to mention the 2023 intermediate track. Since it was recently introduced for civil cases to standardize the process and create certainty around costs, examiners actively noted that they now expect to see you reference this new intermediate track in your answers. So definitely don't miss out on those easy points. Here's another area where a ton of candidates get confused. Juries. If a question asks about excusals or deferrals, like, medical issues, exams, or going on holiday, do not start talking about ineligibility. Ineligibility relates to things like age or specific occupations. They're completely different legal concepts. Oh, and here's a golden nugget for you. Jot down the specific 2022 update under the Police, Crime Sentencing and Courts Act, which now permits British Sign Language interpreters to take part in jury service to aid deaf jurors. Dropping that detail shows exceptional, up-to-date knowledge. Let's jump into Section 4, nailing criminal law. So the crucial point for Paper 21 is that examiners are looking for incredibly strict, methodical statutory application. When you're dealing with the Theft Act 1968, you can't just write some broad, general summary. You have to systematically break down the required elements. Like, did they appropriate it under Section 3? Is it property under Section 4? Did it belong to another under Section 5? You need to work step by step through the scenario. Let's look at exactly how you secure those AO2 marks for a nuanced element like belonging to another. Ricketts v. Basildon is a really fantastic case to use here. If your exam scenario involves donated or abandoned property, use this case to explain the exact legal distinction. A coat left in a bag outside a charity stop still belongs to the donor. But trousers taken from a clearly marked bin at the back of the shop, those belong to the charity. It's this kind of highly specific application that is really going to win the examiner over. And you want to take that exact same methodical approach for aggravated burglary under Section 10.1. Examiners really want to see you explicitly state that, first, it requires a completed standard burglary under Section 9.1. Then, they need to see that at the time of the offense, the defendant had a firearm, weapon of offense, or explosive with them. And a great little detail to remember, an imitation firearm, like an unloaded air gun, absolutely counts for this. All right, Section 5, Contract Law Tactics. A major place where past candidates lost marks was by trying to apply a single blanket rule to a complex, multi-issue scenario. Take the intention to create legal relations, for example. If you get a scenario that involves agreements about a house, a car, and then just some everyday shopping, you can't just write one paragraph explaining ITCLR and assume you've covered your bases. You have to explicitly recognize that those different factual contexts require very distinct legal reasoning. The exact same logic applies to capacity and the Minors Contracts Act, 1987. Top marks do not go to the students who just write a general summary about how minors can't sign contracts. No, top marks go to those who expertly categorize the agreements in the specific scenario. You've got to distinguish the nuances, clearly identify which contracts are valid, and critically, which ones are voidable. And finally, let's wrap up with Section 6, Winning Exams Strategies. Let's talk about your actual physical time sitting in that exam hall. The examiner's report noted that time management is still a huge issue, with way too many candidates leaving blank pages at the end of their booklet. So, here is your number one rule. Always answer the higher tariff questions first. You need to secure those big 25-mark points right at the start when your mind is fresh. Don't run out of time writing some perfect multi-page masterpiece for a question that's only worth 5 marks. Remember, you can answer questions in any order you want. Just make sure you clearly number them. So, there you have it. You now have the insider knowledge. You know to respect those command verbs, you know how to seamlessly blend your case law with your evaluation, and you know how to methodically break down statutory elements. Basically, you're holding the examiner's playbook right in your hands. So, looking ahead to your next practice paper, which higher tariff question are you going to confidently conquer first? Keep focused, keep practicing, and you are for sure going to nail this. Thanks so much for joining me on this explainer.